SJC-12688, Lynn Hlatky v. Steward Healthcare System, LLC.
Mr. Ward, good morning.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court. The principal issue in this case is whether the measure of damages in a breach of contract action can include the replacement cost of property the plaintiff never expected to own, but only ever expected to use. Steward agrees.
What's the implications of the bankruptcy decision about GRI owning the assets of CCSB?
So to the extent that there was any dispute between the parties, Your Honor, and we understand the plaintiff to have waived any claim to the assets, that bankruptcy decision would have resolved it in an issue-preclusive manner, because what the bankruptcy court held was that the grant funding and the equipment that made up the CCSB belonged to a third party, belonged to GRI, and the bankruptcy court specifically enjoined plaintiff from seeking in this litigation any damages that really belonged to GRI. So in this case, Steward agrees, and we agree on appeal, and we agreed below, that to the extent plaintiff actually proved her own financial losses, if she actually had put in evidence of her lost future earnings potential, she would be able to recover that because that's personal to her. However, what she cannot do is the only thing she did, which is try to put in evidence of harm to GRI, of what it would cost to replace the CCSB, which was an asset of this other company, according to the bankruptcy court, and again, according to her own concessions in this case. By seeking damages in that amount, and by the Superior Court awarding damages in an amount equal to the lab's replacement cost, the court ran afoul of decades of this court's precedents, which state that you don't put plaintiff in a better place financially than if defendant had never breached. And importantly, in this case, even though the law generally is that in breach of contract actions you don't get any kind of emotional distress damages, plaintiff in this case expressly waived any right to emotional distress damages or mental distress damages, and also waived any right to reputational harm.
But that's not what I think the plaintiffs are trying to say as far as expectation, that she'd be able to walk into a turnkey lab and continue her cancer research, and that that's the expectancy damages.
And the financial component of that expectancy, Your Honor, is only her own salary, which is $425,000 a year or so for some number of additional years. And plaintiff herself identified this in her testimony at trial. If you look, for example, at Record Appendix 3, pages 26 to 27, plaintiff explained that the reason why she got paid $425,000 a year was that she was able to bring this turnkey lab to other facilities and with all the grant money that flows from it. That's why she makes more than the other researchers.
Because she was able to bring the turnkey lab.
Correct. And so again, if you took, for example, the 6 years that her counsel argued to the jury, she might have continued working after the contract with Steward expired, multiplied that times 425, you get a number that once you reduce it to a net present value is probably less than $2 million. It's not $10 million. Effectively, what the superior, if you think about this functionally, if her expected future income from using the lab was likely something less than $2 million, and she's getting $10 million from the Superior Court, then that additional interest, whatever it is being valued at $8 million.
What about the value of her research?
The research may have had some value to the federal government. They may have been willing to pay.
May have?
Well, I'm sure it did, although it's
May have, huh? May have. That's the problem, isn't it? May have.
Well, may have or probable. At the end of the day, nobody wanted those samples, right? So
Come on.
Well,
Come on.
is that
That's
fair
ridiculous.
to say?
I think it is fair to say, because the bankruptcy estate offered them for free to whoever would take them, and no other research institution wanted them. But put that aside. The important point for her...
It's a big putting aside, though, isn't it?
The important point for her damages, Your Honor, is that her financial interest, and she waived any other non-financial interest, is less than $3 million.
So tell me, what was the jury thinking then? Why do you think they went this route?
Well, the plaintiffs put in at trial evidence from the plaintiff that the cost to replace the lab would be $10 million. They then put in evidence of what it would cost to operate the lab and the amount of grant funding that was in place both in 2012 and in 2014. The problem, and Steward has been arguing this from the beginning, is that those large numbers, the 10 million replacement cost for the lab, all the grant funds, did not belong to the plaintiff personally. And in a breach of contract case, this court has said again and again, plaintiff is entitled to be put back in the position she would have been if there had been no breach.
But there was
and no more.
but there were categories of damages were not broken out. You didn't object to the jury instructions.
We didn't object to the jury instructions because there was no need to. The jury instructions specifically said that plaintiff only could recover for her own personal harm and not for harm to third parties. That's at Joint Appendix, Record Appendix 3, 269 to 70. The jury instructions also instructed the jury that plaintiff could not recover for her emotional distress injury. And before we even got to the point of jury instructions, this is at Record Appendix 2, page 179, the plaintiff waived any right to reputational harm. So all that was left was her financial harm.
So
And
why do you think the jury misunderstood that?
I can't explain, Your Honor, but the reason why we have things like Rule 59E and remittitor is precisely for situations like this one, in which the jury hears some evidence and goes astray and awards categories of damages which it could not properly award.
Can you go back and
The problem I have with your argument is that you and your law firm were not the attorneys at trial. I've read the closing. I read the jury instructions. The closing argument was simply that there was no causation. They didn't make any of the arguments that you're making before us today to the jury.
They may not have made them to the jury, but they certainly made them to the trial court. And if you look at the motion in limine, if you look at the directed verdict motion in the JNOV brief, in every single location, what trial counsel argued was that plaintiff should be limited to her own personal financial losses and that the cost of replacing the lab and of the grant funds did not fall into those categories.
So what do we do with the fact that, I've read the motion in limine and I've read her rulings, and at closing argument, your predecessor is arguing purely that there was no causation here and seems to imply that the issue is the destruction of the lab.
And for purposes of preserving our arguments, Your Honor, I don't believe we were required to make effectively a legal argument to the jury.
But you
Right, we
didn't even
made them-
make this is not, the argument you're making is not a legal argument, it's a legal argument, but it's also you asked why the jury went astray. The jury went astray because you never said to them, nobody ever said to them, you can't give her money that you're required to give her the money that she otherwise would have earned herself.
Your Honor, the jury instructions told the jury that.
The
because
jury instructions did not. The jury instructions basically said that the damages are going to be the amount foreseeable to Steward at the time of a contract.
Your Honor, what the jury instructions told the jury, again, this is 269 to 70 in the Record Appendix 3, is that they were limited to providing her damages for injuries, quote, that she suffered and not for injuries incurred by any other person or entity.
Okay, I understand that. So what, but they also said that they're damages that are foreseeable by Steward at the time they entered into the contract.
And damages foreseeable to Steward at the time they entered a contract in an action by Dr. Hlatky would be limited to, for example, some additional years of her salary after the contract had expired because she could no longer use the lab. It would not include the cost of giving her a laboratory that she never expected to own in the first place.
Argument never made to the jury.
And again, Your Honor, it comes in through the jury instructions, which specifically say only give her damages for harm she suffered personally and not harm suffered by some third party.
Okay, so what if we were to say, and I'll ask your brother in a moment what he would say, what if we were to say, well, the $200,000, it's appropriate to go to her. I think you concede that point.
We do, Your Honor.
$10 million, she can't go and spend it on buying a house in Weston. That money would have to be remanding it to the trial judge to hold the money in trust for the purpose of recreating the lab that she lost.
And that sounds to me, Your Honor, almost, well, there are two issues with that. One, it almost sounds like an award of specific performance, and she never sought specific performance. She only ever brought an action for her own personal damages. The second problem is that it was never incumbent upon Steward to fund the lab in the first place beyond the $300,000 described in the contract.
Not to destroy the lab, wasn't it?
It was to support the lab, Your Honor.
It was to support, not to destroy it the way it was destroyed.
And because the lab is destroyed, look, we're not contesting liability on appeal. All we're contesting is the proper measure of her personal damages, which is what she was limited by the jury instructions to obtaining. Her personal damages were something less than $3 million because that's all she would have earned if Steward had
Why
fully
isn't the
performed.
value of her research valuable to her as opposed to just the government?
To the extent it's valuable to her, Your Honor, there's the financial value of it, which again is the $425,000 salary she earns by being able to bring
But there's
it.
more to it than that.
There's
It's her
more to-
life's work, right?
There's more to it than that, but that sounds in the nature of emotional or mental distress or reputational harm, and she waived all of those things. That argument also proves too much. I assume judges and big firm lawyers also value their professions and the businesses they've built up over time. However, the law is absolutely clear. You can go to this court's decision in John Hancock. You don't award emotional distress damages in breach of contract cases, even if the impact of the breach of contract.
But isn't this a little different? I'm not talking about her reputation or her profession. I'm talking about her life's work, what she created.
And if some breach of contract caused the practice I built up to be destroyed, I might be distressed by that. But the answer is not some kind of additional award in a breach of contract action. There are tort causes of action. You might have 93A. If she hadn't waived emotional distress, maybe we could be talking about that. But you don't take a contract in which the financial expectancy was $2.5 million and turn it into $10 million, much less $22 million, by positing some additional value to the plaintiff beyond the actual financial expectation of
But
their interest.
do you dispute what it would cost to rebuild the lab? Do you dispute that?
We dispute that evidence was put into the record to support it. Plaintiff put in $10 million. The Superior Court initially, as the court knows, excluded that on the basis that it was too speculative and was unsupported by any kind of expert testimony. The Superior Court ultimately let it in on the basis that the door had been opened. But even when you have that one sentence of testimony in the record, we would say that's not enough. The plaintiff actually has to prove, based upon the preponderance of the evidence to a reasonable certainty, what the damages would have been. The Superior Court tried, in a sense, backfilling support for the $10 million by walking through equipment costs and what operating costs were. But there was no witness at trial, not even Dr. Hlatky, certainly not an expert, who actually said that the way the Superior Court went about explaining the $10 million made any sense and was reasonable as a matter of valuing lab creation costs.
Yeah, but on that issue, you take the position that the value of the lab can't be determined by Dr. Lackey's testimony because it's really expert testimony, but in the guise of lay testimony. But isn't another reason that evidence could come in because the door was opened rather than the limitation on expert testimony through lay witnesses?
Even if it came in, our position is that that one single sentence without any explanation for it is insufficient to support a $10 million verdict. You can't, if this actually had been an expert and the expert had provided the ultimate conclusion and nothing else, that would be an insufficient basis, and there should be no less of a standard for lay witnesses who are in effect testifying as experts.
But generally, when somebody makes an assertion of that consequence, there's cross-examination attempting to attack its foundation, and there was none here.
There was not cross-examination, but again, ultimately the burden is on the plaintiff to prove up the damages case. And what we would say is that if she had shown up and just offered that one sentence and sat back down, and we hadn't cross-examined her, that would be an insufficient basis to support a damages award. Plaintiff would not have carried her burden of explaining why the $10 million is a reasonably certain figure to the jury.
And then in closing argument, there's no argument that the jury never hears that that's an insufficient basis for the $10 million. That's not argued as part of the closing argument.
And Your Honor,
by Steward.
I do not believe that we were required to make
I understand that,
arguments
but
in closing.
you're basically saying to us, we're asking us to undo a jury verdict or a judge's miniature with regard to a jury's verdict for arguments never made to a jury.
Not made to the jury, but they're legal arguments which were made repeatedly to the trial court judge. And I will note that the plaintiff made some kind of waiver argument below. The trial court rejected it. This appears at, I believe it's page 230, well, 324 to 25 in Record Appendix 1. So the trial court understood that the key legal issue in this case, which is whether plaintiff can recover an award based upon amounts that belong to a third party, was front and center
Who's the third
throughout this
party?
case.
Who's the third party here?
The third party is GRI, who the bankruptcy court held was the actual.
GRI was the creation of Steward?
GRI was the creation of Steward, Your Honor.
Yep, uh-huh.
And GRI was the spin-off of Steward Research and Specialty Projects Corporation. The bankruptcy court held in a decision which is no longer subject to appeal that it owned the CCSB's assets and that if plaintiff wanted them, she had to go ask GRI for them.
I understand that you're arguing she's not entitled to a windfall, and that this presents a windfall, but going into this contract and coming out of this contract, she's in a substantially lesser position than she was going in because of the loss of her research and equipment.
And again, Your Honor, that is why we agree that if she were asking for her future lost earnings potential, her own personal damages, she would be able to obtain that because she no longer has this lab, which she testified is the reason why she could make $425,000 a year. You do not, however, value the emotional, reputational, whatever these other nebulous interests are, at the replacement cost of the lab, because that's effectively treating her as if she's the owner. It simply makes no sense to say that someone with $2.5 million in financial losses can get $7.5 million or $20 million in additional damages on top of that because of some nebulous interest, which this court repeatedly has said you don't
Prior
get
to
in breach of
the- I'm
contract
sorry.
cases,
Go ahead.
Please.
and she waived.
Prior to the creation of GRI by Steward, who owned the assets?
It would have been Steward Research and Specialty Projects Corporation.
They owned the assets?
Right, because under federal law, we walk through this in our reply brief, title to assets is held by the sponsoring institution, which in this case would be a nonprofit, so it's either SRSPC or GRI. The grant
But
funding.
if she wanted to move, you didn't have, Steward did not own them in a fashion that they could refuse to transfer them.
The way it would work is we would argue it out in front of the federal grant funding agency, but what's absolutely clear is that plaintiff herself did not own them. She could not, take it and
Would
sell
be
it.
arguing, wherever she went, they would go, right?
She argues that, but the testimony was unambiguous in the record, and we walk through this in our reply brief. If there's a dispute between the then current institution and the principal investigator, then the federal government decides who at the end of the day gets to take it. She did not have an absolute right to
Nor
bring
did
it
Steward.
wherever she wanted.
Nor did Steward, it would seem.
I'm sorry, what's that, Your Honor?
Nor would Steward have an absolute right to retain it.
No,
It's a
that's-
funny
that-
kind of, it's a funny kind of ownership then.
Yeah, you're basically holding it in trust.
Yes,
But
that's right.
But the question still remains, what's her financial benefit from that beneficial interest she has in it? And her financial interest is 425 times some number of additional years. It's not 10 million, it's not 22 million. I know my time has expired. I would like to address their cross-appeal briefly, if I may, Your Honor.
Yeah, but Chief, can I have additional? Before you do that, what if we agreed with the majority in the Pennsylvania case? Is it Ferrer?
Ferrer.
Ferrer, yeah. If we agreed with the majority in Ferrer, would that mean you lose, or can it be distinguished from this situation?
Even if you, Ferrer's a complicated case because there the plaintiff actually, being a tenured professor, kept getting paid throughout the time of the investigation. And so my own sense is that the court felt he should get something, and so gave him the cost of the lab over the vehement dissent of two of the justices. So we think that's wrongly decided for
I understand
several
that.
reasons. If you decide nonetheless that researchers, university professors, who are wrongfully suspended, maybe whose research is disbanded, can get more than just their lost financial interest, can get tens of millions of dollars for other reasons, then we would still be stuck with the problem that the $10 million figure in this case is not supported by competent evidence and is essentially unexplained. I will note, plaintiff did try to provide additional explanation for the $10 million. The Superior Court kept that out. So it's not as if the expectation was it was entirely up to us to cross-examine and figure out the basis for the $10 million. We also know what the basis for the $10 million is from the supplemental interrogatory responses, which are part of the record on appeal, because they were part of our motion in limine. And the explanation Dr. Hlatky gave for the $10 million in those supplemental interrogatory responses bears no resemblance whatsoever to what the Superior Court judge ultimately concluded was evidence backstopping $10 million. So there's no witness who ever did say why $10 million made sense, and there's certainly no evidence, and there was no witness who was prepared to either.
Before you move on, one more question. Your contracts basically said the federal regulation that real property, equipment, intangible property, and debt instruments that are acquired or improved with federal funds shall be held by recipient by the interest by the recipient as trustee. That's what you're referring to, right?
Correct, Your Honor.
So is that her being the recipient, or are you saying Steward's the recipient?
No, Steward is the recipient. So under federal regulations, recipient is defined as an institution. And so Steward Research Specialty Projects, later GRI, is as a matter of federal law the recipient. The recipient holds it in trust, and the recipient is expressly charged by the same federal regulations only to allow the assets and
So
grant
is there a
funds.
separate cause of action under that could have been brought?
Well, at the end of the day, Steward and GRI reached a settlement. So Steward continued, again, we're not contesting liability for
Right.
the appeal, but Steward did continue providing substantial support to GRI even after the spinoff. Steward put a claim in bankruptcy for close to $10 million against GRI because GRI had never paid Steward back for the support that Steward was providing. And those claims were ultimately settled. So, I mean, in effect, what she's saying is, rebuild me this laboratory, give me these grant funds that I concede belong to a third party that entered a settlement with Steward and waived any claims that it itself may have against Steward.
It's not me, as Chief Justice Gans was saying before, it would be in trust for the lab itself.
An
Wouldn't
award
be
of,
that she could spend it on a house in Weston, as he says.
an award of damages, Your Honor, to her personally could be spent on whatever she wants. She has never asked for the relief that Chief Justice Gans suggested. And I'm not sure at this point the court.
Well, it's a legal argument that can be made at any time, according to you.
Well, no, Your Honor, that's not true. Again, I could walk through. I have an entire page which I can hand up to the court of where we preserved our various arguments. But throughout the case, starting with the motion in limine, through the directed verdict motion, through the JNOV, at every time there was an opportunity to argue, we argued that she was limited to her own personal recovery, which did not include amounts that were owned by the CCSB, which was part of GRI.
I'll give you 3 minutes more to argue with regard to the cross appeal.
Thank you, Your Honor. With respect to the cross appeal, obviously that's an abuse of discretion standard. And what this court has said is that it's so seldom, a remitter is so seldom overturned as to almost never occur. In this case, it could not have been an abuse of discretion for the Superior Court to set plaintiff's damages at $10 million on a remitter when $10 million is the value plaintiff herself and her counsel repeatedly identified as the cost of reestablishing the laboratory. We cited 2 instances of this in our reply brief, both plaintiff's own testimony that it would cost $10 million to, quote, get a functional lab together, get people together, and redo the projects. We cited her JNOV brief in which counsel identified $10 million as the amount. But there were several other examples too. So for example, plaintiff's counsel's closing argument to the jury. He said, quote, the CEO of this company told you it's going to take $10 million to put this lab back together. Plaintiff's counsel at the jury instruction hearing, this is page 203 in Record Appendix 2. Hlatky testified it was $10 million or so for the lab. And I could go on and on, there's a few more examples. Ultimately, in her briefing on appeal, she never argues that $10 million is too low for replacing the lab. What she basically argues is that it's $10 million to replace the lab, plus some additional years of operating revenue on top of that. But there are several big problems with that. First, she explicitly disclaimed during her trial testimony any right to grant funding and any right to the operating funds, and she expressly said that the only grants and operating funds that would ever belong to her personally were her own salary. That's Record Appendix 3, page 191 and 199. We also have our basic windfall point, which is that if Steward had performed, these operating funds never would have flowed to her personally. Instead, the evidence at trial was that the lab had about 30 employees, it had many vendors and equipment suppliers. In fact, it also entered into contracts with other laboratories. It farmed off some of the research to other entities. What she's effectively asking this court to do is to give her $10 million for the lab, plus, in effect, the gross revenue for the CCSB. But if this were any other type of business, and plaintiff herself described it as a business of which she was the CEO, you would never award gross revenue to the owner of the business. You would award them their profit. Law couldn't be clearer that you subtract out expenses that were saved as a result of the defendant's breach. And so here, in effect, plaintiff's profit from this laboratory was her own salary. So you would never get from $10 million to $22 million based upon the gross grant revenues, gross operating expenses of the laboratory. Plaintiff also sometimes points to grants that were still awarded but had not yet been used as of December 2012. And they put the dollar figure of $24 million on that. There's a big problem with that too. The evidence was undisputed at trial that by 2014 that had almost all been used up, and there was not $24 million left in grant revenue.
Can I ask another question, Chief?
Sure.
You know, I think that the problem we're having is that it seems to me like you admit liability, but then you say that there's no remedy for that, really no remedy for that, other than, you know, you destroy her lab, you know, the value of recreating it is at least $10 million, but somehow that's not your responsibility. So there's a cause of action without any remedy to it, and that's not something the law usually allows.
That's not correct, Your Honor.
Tell me why.
There were several remedies that we admit could have been awarded here. First, we admit that if she'd actually put in evidence of her own future lost earnings potential, an amount that in our motion to eliminate briefing we said might be $2 million, maybe it's between 2 and 3, she could have recovered that. That would put her back in the position she would have been financially if Steward had performed.
But that's, I think you said if she had, but she didn't.
She didn't, and she admitted she didn't in her post-trial briefing.
But isn't there a
That's why-
fallacy in saying she's put back in the position she would have been in if she can never be put back in that position since her research samples were destroyed?
And breach of contract law, Your Honor, awards financial expectation interests. It does not award for all of these other all these other values like the mental enjoyment or reputation, particularly where in a case like this one, plaintiff waived those. And it's undisputed that plaintiff admits twice in her opening brief in this case that she waived any claim for emotional or mental distress. And before trial, this is page Record Appendix 2, 179, plaintiff waived any right to reputational harm. So all of these other values are just out of this case. We're left with financial injury. And again, even if they were in the case, you'd have to get past this court's decision in John Hancock. You'd have to get past the fact that it simply proves too much. And again, hopefully most people find fulfillment in their job. Most people think they're building something and getting more out of, both giving more and getting more than their own personal salary. But there is not a single example of the court, as a result of that, giving an employee, even a highly placed employee, even an employee who drives business, something more than their own lost financial interest, which is what they're asking here. And it's not, I mean, when you talk about the dollar figures, $7 million under the Superior Court's award, $20 million under the jury's award, those are amounts that sometimes you don't see in wrongful death cases. And I hate to draw the analogy, but this is not a wrongful death case. This is a case about a
Destruction
lab.
of cancer research, though.
She was a cancer researcher, but the court should not come up with a special rule that gives cancer researchers or employees of nonprofits generally more than they would get if they worked for a for-profit corporation. There's no precedent for that, and it would set an extremely dangerous precedent. It would destroy the certainty, which is the hallmark of breach of contract law. If plaintiff wants more than financial expectation interests, that's why we have tort law. That's why we have 93A. We do not have breach of contract law to set sort of boundless damages awards for non-financial interests.
So
in breach of
was her
contract
mistake
cases.
just bringing this as a contract action as opposed to a tort action?
It very well may have been a mistake on their part, but right now we have a breach of contract action in which plaintiff waived reputational, emotional, mental distress harms, waived any claim for harm to third parties, and admits that she did not own all of these assets. Hence, her only financial interest was her own lost future earnings potential, which plaintiff, as a tactical decision, decided not to put in front of the jury because plaintiff did not want mere low single-digit millions. Plaintiffs swung for the fences, asking for 20 to 30 or more millions of dollars. And the fact that that is a legally invalid theory of damages, and as a result, she may be down to $200,000. And we think actually it would be fair for the court to remand to the Superior Court to address our point that she didn't put in evidence of personal financial losses in the first instance. But the fact that she swung for the fences on a legally invalid theory should not drive this court to set a dangerous precedent.
Before you leave, one fast question. You made reference to supplemental interrogatories of Dr. Hlatky. I assume that those were done before trial.
Those were done in the midst of, I believe in the midst of trial, because there was the bifurcation, no, actually, it was before trial. It then came in our motion in limine. So when we're arguing about what maybe we meant by 2 million or the fact that we preserved things, those are part of the appellate record before the court.
I guess more precisely, when there was cross-examination of Dr. Hlatky after she gave the $10 million figure, did you have access to those supplemental interrogatories answers?
We did, Your Honor.
Okay. Thank you.
Thank you, Your Honors.
Mr. Beerwith.
Mr. Chief Justice, may it please the court. I want to start with the bankruptcy decision because that came up a couple of times and I just want to clarify things there. So the bankruptcy court did not decide the issue of ownership. There's this procedure in the bankruptcy court where if there's a bona fide dispute as to ownership and the trustee is in possession of the assets, the court can order the sale or disposition of the assets and the money's taken into the bankruptcy estate and held in escrow. And that's what occurred here. So the judge at the bankruptcy court did not decide ownership and certainly did not decide the validity or propriety of Dr. Hlatky's contract claims. With respect to the ownership issue, Justice Cipher, you're correct that the nonprofit under the regulations holds the federal funding and the assets in trust for the benefit of the program. Right? Ultimately, the beneficiary is the public good. But they hold their title as trustee. That's it. It's not ownership, lock, stock, and barrel of all of the assets. But in the end, the ownership is really a red herring. The plaintiff never claimed that she owned this laboratory or this research program, and we're not seeking to recover for destruction of the lab based upon ownership. We're seeking to recover based upon breach of contract. And there were two promises, two reasonable expectations that Dr. Hlatky had arising from this contract relationship. The first was for support, and we haven't talked about support yet, but support is an explicit term in the contract. It's in page 2 of the contract. And there was testimony that that support runs to the benefit of the individual researcher. That was testimony from Dr. Callum from Steward. And that support, there was testimony also that it entails all of the business operations of running a research program. So that's with Steward's obligation.
Why isn't the remedy for that specific performance?
Well, Your Honor, it's a choice, right? So a plaintiff in this situation can bring specific performance claims or can bring a claim for damages. By the time that the claim was brought, and certainly by the time of trial in 2017, specific performance was not available to the plaintiff due to Steward's actions and ultimately the destruction of the lab.
But then why aren't the damages limited to who actually owns the property?
Well, because what the jury did here is they followed the jury instructions. And the jury instructions were to put Dr. Hlatky, the plaintiff, in the same position that she would have been prior to the breach. So the jury determined that in order to do that, they needed to provide damages that were adequate to recreate the lab and to provide 3 years of operational support. The alternative remedy that's proposed by the defendant of salary only would be inadequate. It wouldn't put Dr. Hlatky back into the position that she was.
I guess the problem is this, and the chief got at it with his question. I guess the problem with that is, why would that go to Dr. Hlatky? That money wouldn't be hers to be able to have a turnkey lab. That money belongs to every family that's craving a cure for cancer.
That's correct, Your Honor. And what that money is intended to do is to get Dr. Hlatky back into the place where she can have an intact lab that she can continue to use, that she has control over as she had prior to the breach, and that she can continue to use to advance the science and therefore benefit the public good. But the recreation of the lab, which was destroyed at Steward's hand, and the operational support to get the lab back on its feet to get to the pre-breach position is a predicate to getting to the point that you're talking about, Justice.
So let me ask you the question I asked your brother. What would you say if we were to remand to the Superior Court judge with instructions that the $200,000 go, I know you want the 22, put that aside for now. given the remittiture, $200,000 goes to her. The judge would then put the other $10 million in a trust for the sole purpose of recreating the lab, so that she could not go and use that money to buy a new house in Weston.
I can tell you, and it's not binding upon the court, or it isn't really relevant to the legal questions before the court, but I can tell you that Dr. Hlatky wants to use these funds to benefit the science, drive the science, further her life's work in cancer research, without a doubt.
Okay, but right now, there's no constraint upon how she would, use the money.
That's a function of an award of damages in contract law. So she is the counterparty to the contract. She is the person to whom Steward made this promise of support, right? She was the person who had a reasonable expectation, this gets to one of Justice Lank's points, of being able to transport this lab to another institution if and when she wants to do that. And that was the custom and practice in the industry, and that was proven in that trial. It wasn't unambiguous that Steward had a right to nix that. The testimony in trial from Dr. Hlatky and also from Dr. Rupnick, who is another researcher who testified, was that the custom in the industry was that the funds follow the researcher, the federal government and the grant-making institutions are interested in the science as it is being conducted by the director, the individual researcher. The funds follow the science, the director of the research program, if they want to approach another institution, they have to be able to bring that, and that is customarily done. And the reason is because no institution, no nonprofit institution that conducts research wants to be known as the entity that doesn't allow free movement of clinical researchers.
But your brother is correct that if there had been no breach and she had remained and she had gotten the support she did,
Yes.
the money that would have been provided to her would not have been for her own personal benefit.
The money that would be provided to her, either the $10 million or the $22 million under the jury award, would not be available for her personal benefit, and she wouldn't need it. She would have what she had prior to the breach. She would have control of the research program, the ability to move it, and a reasonable expectation of support from her host institution. When she contracted with Steward, she testified at trial, look, this contract, there are employment provisions within this contract. It provides for $425,000 to Dr. Hlatky, but Dr. Hlatky testified, and the jury was entitled to rely on this testimony, that the primary thing she was seeking was safety, stability, security at a host institution in order to drive the science. That is her life's work. She's been at this for 25 years, working 7 days a week. There is value there, and that was testified to by Dr. Rupnick as well, to support Dr. Hlatky's testimony.
Well, there's no more noble profession than what she's doing, but that doesn't change the fact that the grant awards don't belong to her. They belong to the institution. So why do the damages belong to her?
So it's not the funding, it's not the grant funding which comprises the jury award. So the jury award was comprised, we believe, of two elements, and I do want to speak to the new trial and the remittitor. But we believe that the jury award was comprised of two elements. Dr. Hlatky testified that there would be $10 million required in order to get a minimally functioning lab. So think of that as the lab space with the equipment, the research program sort of intact but static at one point in time. That's not where she was prior to the breach. So prior to the breach, she had a fully functioning research program that was competitive for federal grants, a history of bringing in federal grants, $24.5 million in committed funds in federal grants. To get up even close to that level, we believe the jury was entitled to look at the contract, which contained 3 years of support, and grant to her damages, which were reflective of those 3 years of support. And she testified at trial without objection that the support that ran through the program was $4 million a year. So 3 times 4 gets you to 12. That 12 added to the 10 to build out the framework of a minimally functioning lab gets the jury to where they were at $22 million.
So what do we do with turning to the record appendix, volume 2, page 168, the motion in limine? Judge Green has a motion in limine with regard to again, you didn't try the case either. Your predecessor's desire to offer an evidence that there was $24.4 million loss in future grant spending. The judge says, I'm not going to allow that in. It's speculative and it's not supported by expert testimony. And moreover, if she had gotten those grants, she would not be the actual recipient of the funds. She's just the principal investigator. Right. So essentially, the jury sort of gave her precisely the funds which the judge said should not come in evidence because they would be speculative and she wouldn't be entitled to them.
Well, I would disagree, certainly, Your Honor, with respect to the $10 million. I
But
can
it's
see
not
your
$10
point
million. I'm referring to the future grant funding, which is the
12.
basis for her remitted.
Right, and the point there, Your Honor, on the motion in limine is that Dr. Hlatky the effort was to try to qualify Dr. Hlatky as an expert to testify as to future funding, the $24 million. The $24.5 million, which I just spoke of, was a fact. It was committed funds. It's in Dr. Honfeld's testimony. There were funds committed from Department of Energy, NASA, NIH, which amounted to $24.5 million. So the jury could look at the contract term, the 3 years, know that the funds were there, intact at the time of breach, available to pay. So it's not speculation, it's not topic for expert testimony about future funding. It's operations which were committed under the contract and which were available to be funded. That money was there in the pipeline to fund the research.
Again, I read the closing of your predecessors. No argument about anything other than the $10 million in closing.
There was argument, Your Honor, about the various components of figures, damage figures, which got into evidence. And Dr. Hlatky testified it was $3.7 to $4 million of support that was of support funds that were run through the program every year.
But are you saying that that was argued in closing?
I believe it was mentioned in closing. I'm not sure if there, I know that there was not a calculation.
Okay, so why did the judge then abuse her discretion in deciding that the $10 million was the only supportable figure?
Well, three things, Your Honor.
Or not the only supportable figure. That's up the standard. Was the more appropriate figure?
Right. So we would point to the fact that the judge really focused on only one potential methodology that she believed, she assumed that the jury had used. And what she believed was that the jury had looked at this support, $4 million a year, carried it out for 6 years, got to $24 million, close enough to $22 million, and Judge Green decided that that was a windfall. First error, legal error on that decision was that she didn't explain her reasons why. And the Turnpike Motors case says that a trial judge, in reducing a jury award, needs to explain for the appellate courts why that remitter is being put in place. Now, the defendant points out that there were other damage figures that were discussed in Judge Green's decision, but if you look at it, she's really using those figures to support the $10 million as opposed to reducing the $22 million from the 10. That's the first legal error. Second legal error is her job is to, the trial judge's job is to look at all of the evidence and see if from anywhere in the evidence, obviously, the jury could come up with the $22 million. And we've put forward this rationale, $10 million, 3 times 4 is 12, that gets the jury to $12 million. It was not considered by the judge at the time, and therefore we think of that as the second error. The third legal error, and this gets to the Ferrer case, which the judge relied on considerably for the award of damage generally, and we believe that was proper, but the judge misread the Ferrer case to believe that operational support was not something that was awarded in that case, but it was. If you look at the Ferrer decision, you'll see that there's reference to fringe benefits and salaries of the employees, maintenance of the animals. The animals were basically the specimens in that case. So those are forward-looking. There's some runway, and there's actually an affidavit that's in the record at RA-1362 from the expert who testified in the Ferrer case, and the affidavit makes plain that the jury award of the $2.9 million in that case was comprised of startup costs and uninterrupted support for 5 years. So three legal errors from the trial judge in considering the remittitor, and frankly, Your Honor, a failure to defer to the fact-finding and to the discretion of the jury. And we believe that the evidence and the arguments support this, and that it's a reasonable award, given the nature of the damage caused by Steward here.
The prejudgment interest actually turns into a serious amount of money. Doesn't the plaintiff have to prove the prejudgment, the breach date? It's not enough for the judge to instruct the jury that December 31st is the breach date. So why are you entitled to that prejudgment interest from that date?
So under the statute, the date needs to be established. Here we had a situation where the judge instructed the jury, as you point out, that that Dr. Hlatky is alleging that Steward breached the contract on December 31, 2012, and it was undisputed. First, there was no objection to that instruction, but secondly, it was undisputed that that was the date when Steward withdrew as the sole member of the nonprofit. And at that point in time, under Steward's own testimony, they abandoned the research. They had no more connection or relationship with Dr. Hlatky. So the jury was asked then to check the box, yes, if it determined that Steward breached, and it did. So the breach is explained to the jury as occurring on a specific date. They checked the box, yes. The jury is presumed to follow the jury instructions, so then it's presumed that there's a finding by the jury of a certain date. And we would direct the court to the Morgan case, recognizing it's a case from the appellate division, but I think it's the most analogous case because there was an implied finding, and the court makes it plain that the trial judge there was a bench trial. There was only one possible date of breach, which was the date of the closing in the real estate transaction, which was the same here. There's only one possible date. It was undisputed, and when the judge found liability and found a breach, the appellate division said that that was an implied finding that it occurred on that one possible date.
Two questions on that. The judge said that you allege that it was 12/31/2012.
Yes.
Which was true. You did allege that. Why should they object to the characterization of what you allege?
Well, because it imports that date. It imports that date into the jury instruction so that if it's true and it's undisputed, perhaps it's just the flip side of saying it's undisputed that they didn't object.
But is that's the second question. If they had left and then, as they continued to provide substantial funds after they left Steward, I mean, it took a while before Steward backed off. So is it so clear that that is the pertinent date when the issue is whether they stop supporting it? And it seems a little bit less clear to me when they stopped supporting it as opposed to when they no longer were a member of the nonprofit.
Right. So there were two counts, remember. So it's breach of contract and breach of the covenant of implied good faith and fair dealing. So the breach of contract, we alleged, occurred at the time of the removal. That's when Steward cut off the support. The damages...
That's when they left. That's when they withdrew.
That's when they withdrew.
The cutoff of
as the member.
I mean, you agree that they did continue to provide substantial funds even after they left?
They did
Advanced
through
substantial
GRI,
funds.
correct.
Okay,
Right.
so support is a little less clear.
Understood, Your Honor. I look at the conduct which occurred after December 31, 2012 as really exacerbating the damages, but not the date of the breach. So if a date of a breach has to be fixed in a contract case, one way or the other. And the breach here occurred when they withdrew as the member. The damages got worse because, as you know, the breach of the covenant of good faith and fair dealing speaks to the performance of the contract, and they, without a doubt, barred or thwarted Dr. Hlatky's efforts to obtain the fruits of the contract by their conduct after the date of the breach. So I think that would speak to that. But the date of the breach of the contract, we allege, and the jury was instructed, it was a date specific.
Let me ask you a question that Mr. Martin raises, which is a point that worries me too. We have a number of cases, and I expect we'll have more, in which Members involved in important research at various academic institutions are terminated or caused to lose their support, either because of sexual harassment or other sources. Difficult cases. When that happens, in every case when that happens, can the professor who ultimately says, well, they actually were not fair in doing that to me, or are they going to be able to obtain damages of the sort that you describe, the benefit of all of their research funding, which could become millions of dollars? And if that's the case, is that going to mean that we've raised the stakes to remove professors who may be engaged in sexual harassment or other conduct which may warrant their removal?
Your Honor, it's a fair question. I think that this is a very unique case, and it turns on what Dr. Hlatky brought to the program and what her expectation was. Right? So it took her years to develop this lab, 25 years worth of work. She brought that to the contract. This is the type of situation where the remedy that the jury reached here is the only remedy, because the alternative to that, Your Honor, is some lesser remedy of salary. But the remedy here is the only one which would put Dr. Hlatky back into the position she was prior to the breach.
What about the tort claims?
So, Your Honor, I don't...
The only remedy, what about a tort claim?
So a tort claim, I mean, of what? Tortious interference with contract? You can't interfere with your own contract. I'm not sure what tort remedy there may be, but in any event, we're faced with a substantial and serious breach of contract and substantial damages that flow from that breach of contract.
And would the same remedy be appropriate if she had been terminated for some alleged misconduct?
Well, that wouldn't be a breach of the obligation to support.
What if it were determined that the termination was ultimately found to be unjust because of a failure of proof or whatever else, which happens?
Well, Your Honor, I think this gets to also that it's not just the use of the lab. Right? The use of the lab isn't the only right that Dr. Hlatky has. She brought this lab to the program. She had control over this research program. She was the one who applied for the grants, and she had the right to transport this program with her if and when she wanted to change jobs. I don't think that that would always be the case. It's not just a research scientist who's engaged in lab work. This is not just an employment contract. It's much more, and the jury was entitled to find that. It's really an affiliation agreement. She's bringing her research program. She had brought her research program to Steward's predecessor 7 years earlier, and this contract was as a result of negotiation. And again, to her, having that stability and security in a research institution was critical. I don't think those facts are going to present themselves all the time, nor, Your Honor, these facts having to do with the breach and Steward's purposeful and egregious conduct here are not going to reappear time and time again. So the magnitude of the destruction here, which drives the size of the jury award, I don't think is something that the court is going to see often.
Okay, thank you.
Thank you, Your Honor.